States Constitution regarding the imposition of fiscal restraints on the federal government, further limiting the power and jurisdiction of the federal government, and limiting the terms of office for members of Congress and other federal officials. We will limit it to 15 minutes, proponent and opponent. Is there any proponent testimony at this time?
Good morning.
Good morning.
Mr. Chair, thank you for allowing me to be here today. We're a little caught outside as I'm running between appropriations and other bills this morning. Just pulling up right now. Obviously, I'm here today to talk about our joint resolution. My name is Brian Mulder, District 11, Sioux Falls. And introducing the joint resolution, obviously this is a topic that is familiar to this committee and this body, as it's been talked about several times over the course of the years that I've been in the legislature. Senate Joint Resolution 503 in the Convention of the States. This is something that honestly, when I first got into the legislature, I thought was crazy. I voted no on this bill several years in a row because I didn't fully understand the impact that it could have. You hear the stories about what takes place or could take place at a Convention of the States. You hear the stories, the narrative on what's going to happen if we actually pass this resolution and other states joined us. But then over time, you learn the impact of what can actually happen at a Convention of States. You learn the safeguards that are in place. You learn that actually, when we look at how Congress is operating, that we're in trouble now. And what are our options to fix that? And what are the options as the states to take back power and let Congress know that we're serious about how we want them to operate? So Convention of the States seems to be the answer. It is the answer. And I had to take time. I had to do the research. As I mentioned, I was a no vote several years in a row. And once I took the time to sit down and listen and say, where is the solution to what's taking place at Washington, D.C., and you understand the safeguards that are in place, which you're going to hear about from our next testifier, you understand that this could be the thing that sets Washington, D.C. on the right track. And so with that, I'm going to turn it over to our next testifier and let him give you some more details on the Convention of the States and SJR 503.
Thank you for the proponent testimony on SJR 503. Welcome, sir. Please introduce yourself and give us your testimony.
Morning, Mr. Chairman. Morning, members of the committee. I'm former senator from Pennsylvania, Rick Santorum, and it's an honor to come back here before the committee and have a chance to testify. And I know you've heard me speak before, so I think I'll just do what Representative Mulder suggested, which is sort of cut to the chase of the concern that I'm hearing from many members about how this will function and the safeguards that are in place. The principal safeguard is the one that the founders put in place to amend the Constitution. The Constitution's, since the founding, has been amended 17 times. 15 are still in place. Prohibition was passed and repealed. It's really hard to amend the Constitution. In fact, it's the hardest thing to do in the United States of America in a governmental entity. There's no body, there's no bar that is as high as getting 75% of the vote. Imagine if you had to get 75% of the vote on any controversial issue here. I mean, it's impossible, particularly in the environment today. Well, imagine amending the Constitution, what the stakes are there, how much consensus there must be. And if you go back and look at the 15 amendments that are in place right now, they had overwhelming support within the American public. That's what passes. I mean, I'll use the example of the most recent failure, which was the Equal Rights Amendment. That was something that had overwhelming popularity, certainly among the elite class and those who were pushing for it, but it failed because it didn't have broad enough support. I just share that with you is that when people say, well, bad things can happen, all sorts of horrible things can be adopted. The reality is no, that's simply impossible. And the founders made it really hard for a reason. The Constitution is the broad base upon which our republic is founded upon, and it has to have a broad base of support. And so the idea that either the far left or the far right are going to use an amendment to the Constitution process to get radical ideas forward is absurd. By definition, it can't happen. And so I understand where people say, well, this could happen, this could happen. I go to Justice Scalia, who back in 1979 was a law professor at the University of Chicago and was asked by the American Enterprise Institute to debate 3 other professors about an Article 5 convention. And just to understand, Article 5 convention is not a constitutional convention. It is not a convention to rewrite the Constitution. It is in the Constitution as the mechanism to offer amendments to the Constitution. And he was arguing about it, and these 3 other professors were expressing concerns. And he said, is there risk of having an Article 5 convention? And the answer is yes, of course there's a risk. But there's a risk today that the Congress today could pass a law outlawing Christmas. Could they do that? Yes, they could. Will they do it? No. Is there a risk? Yes, there's a risk. There's a risk when you get up in the morning and you cross the street to come to the Capitol. It's a risk of getting hit by a car. We take risk in everything we do. The question is, it is a reasonable risk. Is it a risk worth taking, given the unlikelihood of something happen versus what we know is going to happen? $38 trillion. $38 trillion is what our national debt is right now, and it's skyrocketing. I just saw a report out that, yes, revenues are up, but entitlement spending is even going up more, 9, 10%, in a time when at least some politicians tell us we have a great economy. The reality is Washington has no governor on it. And I live in Washington area, and I've been in the Washington area now for close to 30 years. And I'm here as someone who understands, knows, works in Washington, ran for president a couple of times. I know a lot of what goes on in that town. And I am here because, like Representative Mulder said, I was not originally a supporter of this. But the more I got into it, the more I recognized the founders were smarter than I was. They realized a time would come in America where an intervention was needed. And guess who they trusted? You. If you look at the original Constitution, they trusted you with controlling Washington, D.C. They trusted you as the people closest, not your governors. The authority rests in the legislatures and the legislatures alone. You're the ones who pass the resolution. You're the ones who ratify the amendments, not anybody else, because they came from the states. These were state legislators themselves, and they trusted you as the people closest to the people to control what they were worried about is every republic which fails from authoritarianism. And so here we are as an opportunity for the state of South Dakota to join another state that just passed a couple of weeks ago, Kansas, to become the 20th state to adopt this. There are 2 or 3 other states this year that we think have a reasonable chance. As you know, it passed in the Senate 25-9, and we're hopeful that South Dakota will be the 21st state and speak loudly to what's going on in Congress and stop the insanity. You say, well, what are you going to do? I'll give you an example. You say it's going to be really hard for anything to pass. The reality is there are things that are common sense things. And when I legislated in Washington, it's really hard to cut a benefit. It's really hard to make changes to take something away from people. But one of the things that you can do is you can stop bad things from happening. And one of the things I talk about all the time is the idea of having an amendment that is proposed and I think would be ratified to limit the Supreme Court to 9 people. That would be an important thing to do. It would send an important signal to both parties that court packing is not the right way to go, that trying to seize control of the federal government through means is not the right thing to do. You could do that. That's the kind of thing that I think would come out of a convention, but no radical things. I know people talk about, oh, we're going to balance the budget, we're going to do all these things. You're not going to get 38 states to vote for those things. You're going to get 38 states to do things that keep the guardrails on. And more importantly, why I'm so much in favor of you folks having a convention is because you assert yourself, I should say reassert yourself as the top of the food chain. Again, under the Constitution, you were the top of the food chain. State legislatures appointed United States senators up until 1912. For 150 years of the Republic, you controlled Washington, D.C. You gave it up. And look what's happened since. The federal deficit prior to 1912 was basically zero. Washington, D.C. was not involved in your lives and the lives of your ancestors because they had no authority to do it. Once you took away the power to control Washington, D.C. by controlling the Senate, well, Katie barred the door. You have an opportunity now to do something at a critical time in our country's history. And I just hope you look at it and say, bad things can happen. Well, bad things could have happened at the Constitutional Convention. Bad things can happen every day when you meet here in the legislature. But you take the responsibility to do the right thing at the right time for a country that desperately needs it. And I hope you do so. Thank you.
Thank you, Senator. Any other proponent testimony?
Good morning, Mr. Chair and members of the committee. My name is Shirley Meyer. I'm from District 14. I'm a volunteer state director for Convention of States. My testimony today is about the process. A lot of people don't understand the whole process. Rick Santorum skirted around it, but the whole process is once 34 states have passed this basically the same resolution, they can call a convention for proposing amendments. And that's all you're doing is proposing amendments. Once your state legislatures have passed that, they will select the delegates. Your state legislators are the ones who select the delegates. They give them their commission and they send them and they meet together. Just like you do here, they will break up into committees. Our resolution has 3 parts to it. They will break up in 3 committees. They will come up with the amendments. I can't tell you what the amendments are or what the wording will be because it hasn't happened yet. In order for any amendment to come out of that meeting, each amendment has to be approved by 26 states in order to come out. Once they come out, that amendment cannot be changed in any way. If they try to change the wording or anything, it is dead and void. Once they come out, then they go out for ratification. Each amendment that they come up with has to be ratified by 38 states in order to become a part of the Constitution like the 27 we have. That is the whole process. So for it to be able to run away or something in there, you have to have a majority of the people across this country approving of it. So I am asking for your yes vote on SJR 503. Thank you very much.
Thank you, Ms. Meyer. Any other proponent testimony? Okay. Online then, there is 3 on my list, beginning with Linda Schauer. Oh, no more proponents. Okay, sorry. Well then, with that, we will close the proponent and move to opponents. Are there any opponents in the room? Start in the room first. You need help from a page? Yeah. Thank you, Representative Jameson. Good morning.
Good morning. My name is Michael Boyle. I'm a pastor from Parkston, South Dakota. And I just want to speak to some of the proponent arguments while my exhibit's being passed out. One of the things that you heard so far this morning is that this is going to put the state government back on the top of the food chain. This is your guys' opportunity to assert your dominance. And I just want you to remember that idea because we're going to be talking about that as I get into my testimony. Only majority support will pass, because a lot of people are required to get this thing through. And, you know, we have had 27 actual amendments, not 17, but which one was the popular one? Was it the 18th or the 21st? Which one was the popular one that required all the support? What about the 17th? I think probably a lot of people in this room would agree that the 17th was, looking back, not a great idea for the states. But it actually had overwhelming popular support when it went through. We are told that the founders trusted you to control the federal government through this Article 5 process. And finally, we heard that we aren't going to get a balanced budget, and we're not going to get any cuts in benefits. The only thing that we're going to get out of this is maybe limit the Supreme Court to 9 justices. So I want to just introduce this information here that you have now hopefully in your hands. Up until last year, you know, one of the proponents said we've been doing this for a long time, and that's true. And up until last year, we really didn't have any federal guidance on what does the application process look like and what does the state authority have from the federal perspective. And we had a lot of Supreme Court cases on Article 5, but they were almost all dealing with the ratification. Once we actually have an amendment, what is the process of ratification? This case, Thompson versus Masterson, from November 5th of 2025, that's when the ruling came down, is the first case where we actually look at what is the state's rights or role under Article 5 as far as the application process is concerned. And just to give you a quick backdrop, Kansas wanted to pass the COS Article 5 resolution, and they did do that by a simple majority, but their constitution required a 2/3 majority in order for it to pass. And when you think about the state's control over the process, there is no higher authority than our constitution. And so Kansas wanted to put it in their constitution to say, if you're going to pass this, you got to get 2/3, right? The idea of this has to have overwhelming majority. They didn't have that, but they did get simple majority. And so they went to the federal court and said, hey, you can't force us to get 2/3 because this is a federal process. And the Kansas court agreed, the federal court, agreed with them. This is a federal process. And if you want to turn to page 4, I highlighted for you, it says the court has held that state legislatures' power under Article 5 to ratify a proposed amendment has its source in the federal constitution. It's a federal function derived from the federal constitution. And I quote, it transcends any limitations sought to be imposed by the people of the state. And then if you go to page 10, and a lot of these first pages are just kind of laying out standing, and there was somebody who wanted to intervene. They did not allow them to intervene. But one of the standing arguments is this a political question or is this a judiciable question? And they wanted to argue, the defendants wanted to argue that this is a political question. The court shouldn't be ruling on this because this is a political question that the states need to decide. And the court said, no, this is not a political question. This is a constitutional question. Is it the Constitution of Kansas that's over the Article 5, or is it the U.S. Constitution that is over the state constitution? And the court decided what Congress might choose to do with such an application is up to Congress to decide. Why did he say that? Because it is a judiciable question, the question that they were answering, which is, can the Kansas Constitution limit Kansas legislator as an actor under Article 5? And the reason he said that was because under Dillon versus Gloss, as a rule, the Constitution speaks in general terms, leaving Congress to deal with the subsidiary matters of detail as the public interests and changing conditions may require, and Article 5 is no exception. So Congress is the one that's going to fill in the details, not the states. It's not a political question. And then if you go to page 13, you'll see that it says, there appears to be no controlling precedent considering the application clause, as all the previous cases were just the ratification. But he notes that the authority is still from the federal Constitution, and therefore a previous case, Ohio did not have the authority to pose a referendum requirement on its legislators' ratification process. In other words, any constraint imposed by the state constitutions affecting the Article 5 power were ineffective. And then he deals with Hawk versus Lesser, which dealt with the ratification clause. And it says that the text of Article 5 suggests that logic applies to state legislatures' application as well as ratification. Article 5 uses the term legislators in both ratification clause and the application clause. They have the same meaning in both. Then he goes through other precedent in circuit courts and other courts because the Supreme Court has not ruled on this, but makes a lot of wonderful points we don't have time to get into. But if we go to page 19, it says the effort fails because the application power is conferred not by state law, but by Article 5 itself. And so basically, he lays out in kind of leading up to his decision that this is a federal process. The states will not have control over the process. So then we get to what are the defendants' arguments. The first argument is that Section 13 is constitutional. This is Section 13 of the Kansas Constitution, requiring 2/3 vote, is constitutional because it still leaves power to apply for a convention in the hands of the state legislature. So even though the Kansas wants to have some power over the process, a lot of the power is still in the hands of the legislator. And the judge rules Article 5 permits no limit on state legislators' power to ratify amendments or apply for a convention. Because it's part of the federal process, no state limits can be placed on it. Next, the defendants contended that history and tradition are on their side. The idea is that history and tradition, if appropriately examined, it is clear that the intent of Article 5 was not to limit how the states choose to exercise this power. That's what we're told by the proponents. You have the power. The founders gave you this power to exercise control over an Article 5 convention. The federal judge said no, because Article 5 of the Constitution has its source as the ratification and application, the same source of the ratification and application power. The power does not derive from state law. Finally, defendants contended that Hawk is inopposite because application for a convention under Article 5 is a legislative function. And what they're arguing here is, yes, if we get an amendment, all we can do is vote up or down. That's true. But under the application, we have legislative function. If you look at their proposal under Section 9, you'll see a whole bunch of things that they want to control the process. The application is more like an ordinary lawmaking function. This is what the defendants argued. And the judge said, no, there is no writing of any law or assenting to it. A vote to apply for a convention is simply a vote to convene. That is all the power that you have. You do not have the power to control. He concludes there is no reason to conclude, and defendants have made no compelling arguments suggesting that state legislatures are making laws when they apply for a convention, a constitutional convention. Instead, the cases and commentators conclude just the opposite. And so I would encourage you that you do not have the power that the proponents think that you have, and I would suggest that you vote no on this resolution. Thank you.
Thank you, Mr. Boyle. We're at about 9 minutes. I know we have about 3 folks online. Who else is an opponent in the room?
Hello, Chair. My name is Scott Granville. I'm from Pierre. I represent myself, and I'm unpaid. And I'm in opposition, and I beg that you too oppose this bill. The first word is apply. Apply. There is a simple word, and we do it all the time. I apply for a tax refund. I apply for a driver's license. I apply for concealed carry permit. With that application, I don't get to write the rules. The rules are provided to me by the body that I'm asking for the application from. And in this case, as my colleague made clear, it's Congress that writes the rules. The Convention of States doesn't get to write the rules. They've got section after section after section, safeguards designed, but those safeguards are me telling the GFP how many fish I can catch. That's not the case. Now, we can agree with the Convention of States that our Constitution is sound, and we can agree that Congress has been a bad actor. But rewriting the rules or applying to Congress isn't going to solve our problem. So please vote no on the Senate Joint Resolution 503. Thank you.
Thank you, sir. Any other opponents in the room? Okay, moving to online. The first one on my list is Linda Schauer. Ms. Schauer, can you hear me? Okay, we will move on to Eldon Stahl. Eldon Stahl, can you hear me?
I can hear you.
Please state your name, who you're with, and proceed.
Eldon Stahl. I'm with myself, representing myself. And so I'm opposed to SJR 503. Number one, South Dakota has two other applications on the books right now for Article 5 Constitutional Convention. One asking for a federal balanced budget amendment and another asking for a term limits amendment. Both would be covered in this resolution. The Senate just passed another resolution asking Congress for a convention for an amendment to keep the number of Supreme Court justices at 9. So is SJR 503 redundant, asking for 3 or 4 separate conventions, or are we just trying to expand the agenda of a single convention? Number two, if the legislature itself can't agree why it wants a constitutional convention, and many other states can't either, why should we expect the state delegations to such a convention to limit the convention agenda? Now, if you say state law would limit delegates, how do you expect to exercise jurisdiction on a crime carried out, in all probability, at a convention held outside South Dakota? Third, shouldn't we at least consider the reservations held by James Madison, father of the Constitution, about the wording of Article 5? For example, from Madison's notes of the 1787 convention, September 10th, quote, Mr. Madison remarked on the vagueness of the terms, call a convention for the purpose. How was a convention to be formed? By what rule decide? What was the force, or what the force of its acts, end quote. And from September 15th, quote, difficulties might arise as to the form, the quorum, etc., which in constitutional regulations ought to be as much as possible avoided, end quote. But proponents will tell you such concerns were dreamed up by 20th century progressives, and the founders knew exactly how a convention would work. Well, if so, why didn't the father of the Constitution know? And why did he have such concerns? And last, amazingly, you just heard proponents say it's impossible to add dangerous amendments to the Constitution. In the same breath, they talked about the 17th Amendment, how you gave away state sovereignty. And by the way, we also have the 16th Amendment and the 18th Amendment. This is income tax, losing state sovereignty, prohibition. By the way, the 16th and 17th, South Dakota, unfortunately, unanimously ratified back in the day. I read the journal. Let's not get fooled again. So I would say for the 14th time in 13 years, please kill this resolution. Thank you.
Thank you, sir. Any further opponent testimony? None online. Okay, well then we'll offer the prime or his or her designee a chance for a rebuttal.
Thank you, Mr. Chairman. Rick Santorum again. I want to address the pastor's comments on Kansas. Kansas is a situation in which the people of Kansas amended their constitution to require a 3/5 vote on any Article 5 resolution. There is something called the Supremacy Clause in the United States Constitution, which lays out that the federal constitution, if it's in conflict with the state constitution, is supreme. And it's interesting because for a long time, COS tried to pass in Kansas, and we were thwarted by the 60% requirement, the 2/3 requirement, I should say. And it wasn't because of the Kansas Constitution. It's because the legislatures themselves passed rules in their rules when they would convene to require 2/3. And if the legislature did that, we would attempt to get 2/3 and we lost, and we went away and went home. Why? Because the legislature can raise the bar. Why? Because the Constitution gives the legislature the power to set the rules for approval of a resolution, not the people of Kansas. So this was not an issue. I don't know what, I can't go through all the things he said, but this was an issue that said the United States Constitution gives the legislature sole power to approve resolutions, and the state constitution through the people cannot raise the bar. So it was just a clear supremacy clause issue. What happened is not only did before that court case came down, the House and Senate rules were changed to not reflect the 2/3 requirement. And therefore, once that happened, then it passed. So it had nothing really, the court simply stated the truth that had been there for a long time, which is the state constitution can't trump the federal constitution. What changed was that the legislature changed their rules, which mirrored the Constitution, and they said, well, we don't want to do that anymore, and that's how it passed. So that's sort of a simple explanation. Happy to take questions on that. On the issue that the second gentleman testifies that we don't know the rules and we don't know what's going to happen. There have been 400 applications over the course of our history to call for a convention of states. 400 applications. 49 states have passed applications. Someone just mentioned that 2 are currently here active in South Dakota. Yet we've never had a convention of states. So people say, well, people can go to that convention and do whatever they want. We don't know what the rules are. We don't know what they're doing. Well, if we've had 400 applications, why haven't we had a convention? 49 states have passed it. The reason is because there hasn't been 34 states who have passed the exact same language. When you pass a bill in this House and it goes over to the Senate and they change 2 words, does it go to the governor for signature? No. The exact same language has to be in common with all the bodies involved before you. Reason is because we have to know what the exact language is. Why? Because the language matters. And so for people to say, well, we've had 400 applications, we've never had a convention, but the language that the states have passed, and by the way, 20 states have passed the exact same language that is now before you. To say that language doesn't matter when it gets to the convention is ridiculous. If it matters to call a convention that you have to have the exact same language of 34 states, then it matters at the convention. I mean, it's just simple logic. And so you are limited. Now, I know there are legislation being considered. Representative Heineman has a bill to put teeth in requiring your delegates, as I think about a dozen other states have already done, to adhere to the limitations that are in this language, that you can't go beyond the language and go into other areas. But there's also just the reality that the language matters and it is limiting in its nature. And finally, again, with the rules, there have been since the founding 20 conventions of states. Now you say, well, there's never been an Article 5. That's true. But there have been other conventions of states. Probably the most popular one, most recognized one, is the Colorado River Compact. The states in the area of the Colorado River passed resolutions within their legislatures to call for a convention. And the states came together. They had one state, one vote. California had the same number of votes as Arizona and Colorado. In fact, all 20 conventions to date, one state, one vote. You folks run in this body by rules, but you also run by something else, precedent. And there we have a precedent throughout the history of the Republic. Prior to the history of the Republic, every colony, one state, one colony, one vote. We have a long history of how this operates. In fact, you have a provision in your law that says if it's not, you don't participate. So there are plenty of safeguards here, in addition to the high bar that's necessary to be able to actually get something ratified. And the final point I'll make is, yes, I said that probably a balanced budget amendment would not likely pass. Why? Because you need 38 states. And I'm looking at, 14 or 15 pretty solid blue states that make it pretty hard for me to see how that could change. Now, life could change and things could happen differently. But even proposing an amendment to the Constitution and having a national debate about it would be a positive thing. I just remind you, this would be the first time this is ever done in the history of our country. The attention paid to this. Every kid in high school is now going to have to read the Constitution, learn about federalism, learn about the role of the state government versus the federal government, learn the history of our republic, much of which is not taught in our schools today. It's an opportunity for education. It's an opportunity for you to step forward out of the shadows and begin to reassert your authority that you have under the Constitution. And it's high time we get to it. Thank you.
Thank you, Senator. With that, we'll close the taking of public testimony and turn it over to questions from the committee. Are there any questions? I have one for Senator Santorum, if nobody else wants to start. Maybe an easy question, I don't know. It's just, thank you.
Thank you.
I was thinking back, I think you ran for president in 2012, and I was looking at the
And
national-
2016, people
and-
forget about
okay,
that.
yeah.
I do too. I like to forget about that. Guy named Trump was a little different.
Yeah. Well, in 2012, you should have won. Let's put it that way.
Thank you.
So the debt was about 16 trillion when you ran for president the first time.
Yeah.
Now it's 39 trillion. And I'm just wondering, I mean, in your best estimate, how much time do we have left as a country to deal with this until it all hits the fan if nothing happens with the national debt?
The best way I can answer that is you have time until you don't. I mean, and I don't know what that time is. You have time until you don't. And I you can talk to a million economists and they'll give you a million different answers to when that is. But I think we're starting to see some of the cracks. I mean, you're starting to see it with crypto. You're starting to see it with the value of the dollar. You're starting to see it with a whole host of other things that are very, very disconcerting. And I would make the argument that the accumulation of wealth that we see increasing in this country is a big part of that rationale. What's happening with the value of money, and I don't know, but at one point we're going to wake up and it isn't going to be pretty, and everybody's going to be looking at you saying, "Why didn't you do something if you could?" And you could do something, and I hope you do.
What do you have to say to people on this issue that say if we call, this convention of states, many of us have worked hard on civics education, for example, and trying to ramp that up because it's at an ebb. People say, this is not your founder's country. We call the convention of states and all the things that the opponents have said. Can you speak to what people could try to predict would happen?
Yeah, again, there are guardrails in place, and I'm a bit of a student of the Revolutionary War period and studied a lot on it. And one of the things that I am always, when I hear this argument, I think about all the scoundrels, and we had some great people, but these were not angels who created our country. I mean, Benjamin Franklin was not an angel. I mean, you can go on and on and on. I mean, a lot of the people who were, putting this thing together would have been run out of town in the current American political climate. So the idea that we don't have the ability as a country to deal with this, I always go back to this. My father was part of the greatest generation. You know what made him the greatest generation? Were they somehow better than the rest of us? Were they better than our generation? No, they weren't, in my opinion. They're not. But what they were is what Americans have always been. which is when we need to step up, we do. And at some point, we're going to face a crisis, and maybe soon, and hopefully we'll have another greatest generation stand up to meet that crisis. But that's when you find out. You don't find out. I mean, it's like that you find out the character of a person. You don't find out the character of a person when things are going well and everybody's doing great. You find out when a crisis comes and you have to confront it. And I believe America in its soul and the DNA of America is still terrific. And I am not down on the opportunity for us to give it a try.
Thank you.
Thank you.
Any other questions? Representative Overweg has a question.
Thank you, Mr. Chair. Well, it can be for the senator if it wants, or the prime. So thank you. You know, I worry about when we do things, but to me, it's important how we do things, right? And what my scare is this. We stand here every year and beat our chest proudly that we have a balanced budget in South Dakota, but we're balancing that budget with fictitious money from Washington, D.C. We're a welfare state. And I would say there's probably a lot of states like us that are welfare states. And I'm a pretty conservative guy, but I realize that if all of a sudden the money spigot from Washington shut off, this state would come to a screeching halt. So my question to you is, if I vote for this today and this happens all at once, how do we stop basically the country from stopping so hard that everybody runs into its rear end?
Yeah, I think you actually make the point that I was making, which is it's great to go out there and talk about, you know, all these tough fiscal restraints to get this $39 trillion under control. But I think the most likely thing to do is, again, for things to come out of this convention that will put guardrails on future growth as opposed to cutting things. When I was in the United States Senate, I was the author and managed the bill on welfare reform. And we were able to pass welfare reform. It's the only time we ever cut a federal entitlement in the history of our country. Let me repeat that. It's the only time we ever cut a federal entitlement in the history of our country. And the way we did it was, I hate to say this, we spent more money. We actually spent more money. We actually came forward and said, look, we're not going to cut any welfare. We're going to actually spend more money in this category, but here's what we're going to do. We're going to give the money to the states, and we're going to give them a block grant, more than what they get now. So we gave them a block grant and we capped it. We said, that's it. And if you need to have more, then you have to come back and we have to appropriate it. It's not automatically you're getting this money. And we got enough Democrats and Republicans to vote for it. It's interesting what's happened. Since it's called TANF, you folks are familiar with TANF. Do you know how many times TANF has been increased since 1996? Never. Never. We spend the same amount of money on welfare as we did in 1996. So there are ways. Why? Because we gave it to you when you were innovative and you did things with that money. You had more money you never knew what to do with. And what happened was welfare rolls went down by 80 to 90% because you get people back to work. Now, subsequent administrations have whinnied some of that away. My point is, I think we have to look in terms of putting guardrails in, as opposed to going with a meat cleaver trying to cut things. That's never going to pass. It's just not. But if you can do things to create structure that help control spending, that's where you can be successful. And so I think something like that is much more likely. And that's going to be, again, I don't think people realize what a big deal this is going to be. This is going to be a national event. There's going to be all sorts of media coverage. There's going to be this will go on for, I'm sure, 2, 3, 4 months. You'll have people coming in testifying about every single word on the amendment. It's going to be, I just think it's going to be a wonderful rebirth of American, citizenship and civic information. And that's one of the reasons I'm here, because I think that's, as was mentioned, that's absolutely essential for us to understand. You don't know where you're going unless you know where you've been. And unfortunately, we have an increasing society that doesn't know that. This is an opportunity to do that.
Any other questions? Representative Gosh.
Thank you, Mr. Chair. So we've heard this conversation time and time again. I guess I would ask, what's your stance on the 17th Amendment?
Well, as a United States Senator, I look at it two ways. I would never have been appointed a United States Senator by my state legislature. So I'm a United States Senator because we had a popular vote. So it'd be hard for me to go back and say, gee, I think we should change it when I would have never been one in the first place. Having said that, the reality is the American public wanted remember, it was the time of women's suffrage. It was the time of the country moving in a direction that wanted a more representative republic. And so that was part of that progressive era, which caused that. Do I think it was damaging to federalism? Absolutely. Do I think the founders had it right? Absolutely, they did. Do I think there's any chance that the 17th Amendment is going to be repealed? Absolutely not. The American public are not going to give up their vote. But what happened, and you can look at it, what happened after the 17th Amendment was passed, I don't know if you know this, but prior to the 17th Amendment, 1912, in order to get a bill considered in the United States Senate, right now you need 60%. It's called cloture. You need 60% of the Senate to agree to vote on something. Prior to 1912, you know what percentage it was? 100%. One senator could block a bill from coming up. And guess what? They didn't do much because it required give and take and consensus building. And so the federal government was very small because the Senate, I know everybody complains about the Senate now. There was enormous anger at the United States Senate because nothing got done. Why? Because you guys in the state legislatures blocked it. And so there was that boiling point, and the pot and the top came off. I think it's harmed the republic. It did harm the republic. There's no question in my mind. But that's not something that we're ever going to put the genie back in the bottle.
Follow up.
So the 17th Amendment, and we've got some kids in here, so I want to kind of get into a little bit into the weeds here. But so the 17th Amendment wasn't put in place by a convention. It was put in place by Congress.
It was put in place by, actually, if you look at it, state after state after state were passing resolutions to change. So the state legislatures were passing resolutions to popular elect. And in fact, you were seeing a move that was getting close. In fact, they were getting very close to the 2/3 required. And that's when the Congress stepped in and said, okay, we'll do it. And we'll do it under, they didn't like the language the states were doing. So they did it their own way, and they did it gradually, and they phased it in over 3 elections.
Mr. Chair.
Follow up.
So just to be clear, they did not use a convention to do this. They didn't pass resolutions for a convention to do that.
Yeah, they did. Many states did. And it precipitated the Congress to come in and sort of cut off what was eventually going to happen, which is the states were going to call a convention to change this. And the Congress said, okay, we see this is going to happen. We're going to get out ahead of this and just do it ourselves. That's what happens.
Mr. Chair.
Follow up.
Are you worried that the exact same thing could happen here, where they say that they are seeing these resolutions being passed and therefore want to amend the Constitution to get out of it?
Yeah, I don't think 2/3 could pass in that, and anything could get 2/3 vote in the United States House and Senate right now. I mean, it's just not a functional body right now. So no, that's one of the reasons I'm here, is because I don't think anything you can't get that kind of consensus unless you have a super wave election where one party takes control. I don't see anything like that happening. There's no bipartisanship at all left in Washington.
Any other questions from the committee? Rep. Lems.
Hello, Senator.
Hello, Representative.
So I'm hearing about a bill that's coming that's going to be specific to how the delegates are chosen. I know that bill isn't before us today, but that was one of my concerns in the past. How are these delegates going to be chosen? Can you speak a little bit more to that?
Every state gets to determine how they select their delegates. I don't know, Mark Meckler, who's here, maybe you know the number of states, but it's over a dozen have delegate selection laws in place. And overwhelmingly, I think 12. There you go. Have delegate selection laws in place, and all of those are chosen by the legislature. By the House and the Senate get to pick them. I think there are some states that allow the governor to pick one. Not necessarily I would agree with that, but nevertheless, that some states have done that. And so you can, and I would argue should, do that here in South Dakota, but you control that. So people say, well, Congress is going to run anything. I mean, that's not how it works. The Congress simply calls the convention. They will recognize that 34 states have passed this identical language. They will call a date and time, and then the convention, like the Republican or Democratic National Convention, they will meet. They will have a committee on rules. They will have a committee on arrangements. They'll have committees on everything to decide how the convention will operate. The Congress will have nothing to do with it. The Congress in the past had tried to do this, but they never succeeded. And again, I don't see any possibility of that happening now.
Okay. Any other questions? Okay, thank you, Senator. Seeing no further questions, we'll move to committee discussion and/or action on SJR 503. Representative Heineman.
Thank you, Mr. Chair. I move to pass.
Motion by Heineman, seconded by Hansen. Do pass. Is there any discussion? Representative Heineman.
Well, I appreciate the conversation that we've had and a very good explanation. It's difficult to revisit this discussion because fatigue starts to set in as well. I get that. I think I've heard this presentation 8 times, not more than that actually, but 8 different legislative sessions. But I come back to you can go through all the details and spend a lot of time arguing with your friends, which I consider friends. But it comes back to the issue of it takes 34 to call it. It takes 38 to ratify anything that comes out. And those of you that don't trust that system, that's a high bar. We have in our state constitution a 50% plus 1 with the people. I don't know about you, but that's easy. We need to change that. That's my opinion. The Constitution should be protected, I think. That's an important basic item that we need that should not be changed on a whim. And 50% plus 1, this is 75%. So think about that. That's what it takes to get any changes done out of that convention. So to me, that's the best safeguard you can have. I would urge you to support this motion.
Any other discussion on the do pass motion? Okay. Well, and with no further discussion, the motion is do pass on SJR 503. I will ask the secretary to please call the roll. All in favor will say aye. Those opposed, no.
Representative Baumüller.
Aye.
Emery.
No.
Gosh.
No.
Hansen.
Aye.
Healy.
No.
Heineman.
Aye.
Jamison.
Aye.
Lems. Aye. Reich.
No.
Schaefbauer.
No.
Soy excused. Overwig.
No.
Odenbach.
Aye.
6 ayes, 6 nays, 1 excused.
Thank you, Madam Secretary. After failing to receive a majority of members elect, the do pass motion fails. Representative Gosh.
I'd move 41st day.
Second.
Motion by Gosh, second by Reich to move to the 41st day. Any discussion on that? Okay, no further discussion on that. I'm going to ask the secretary to call the roll. The motion is 41st day. All those in favor, aye. Those no.
Representative Baumüller.
No.
Emery.
Aye.
Gosh.
Aye.
Hansen.
No.
Healy.
Aye.
Heineman.
No.
Jamison.
No.
Lems.
Aye.
Reich.
Aye.
Schaefbauer.
Aye.
Soy excused. Overwig.
Aye.
Odenbach.
No.
7 ayes, 5 nays, 1 excuse.
Okay, after receiving a majority of members-elect, the 41st day motion passes. SJR 503 is sent to the 41st day. That concludes our agenda for today. Reminder, we'll meet again after we gavel out 15 minutes later. So at this time, the chair will entertain a motion to adjourn. Motion by,
Okay, folks, you have been watching a hearing of the South Dakota House State Affairs Committee in consideration of our Article 5 Convention of States application, SJR 503. The vote was 6-6 on the do pass motion, so that motion failed. One member of the committee was excused absent today, and I believe that is what ended up dooming us in this committee. The committee then took up a motion to move the bill to the 41st day, and that motion passed by a vote of 7-5. And frankly, folks, I'm going to have to refresh myself on the South Dakota House rules to remember exactly what that means. But I think that is a procedural move to keep the resolution from being brought up again before this committee this session. So I know that I and our South Dakota team will be looking again at the South Dakota House rules to see if there is any procedural way we can still get our application out of this committee. And again, there was one member who was excused absent today, and that apparently led to our failure this morning in this committee. I believe Producer G is going to be working to get our regional director, Deanna Beckett, up for an interview so we can hear her thoughts on what happened there. We also saw South Dakota Volunteer State Director Shirley Meyer was in that committee and gave testimony this morning. Shirley is a longtime powerhouse Convention of States supporter and volunteer, so I'm hoping we'll get to hear from her as well. So just a brief recap, we heard from our House sponsor, Representative Brian Mulder. He introduced the resolution and explained that he used to be an opponent because he didn't fully understand the impact that Convention of States could have, the impact the states could have in using their Article 5 power. Then he talked about learning the safeguards of the process and the potential that COS had. He said, "We're in trouble now. Convention of the States seems to be the answer. It is the answer." So great job by Representative Brian Mulder, our House sponsor this year. Senator Rick Santorum spoke next. He talked about how a convention would function and the safeguards that protect the process. He explained that it is really hard to amend the Constitution. It requires overwhelming support among the people. And he explained that he too was not always a supporter of COS. He said, "You, talking to the committee members, can do the right thing at the right time for a country that so desperately needs it." Now, unfortunately, this committee did not choose to do that right thing so far. And it looks like we have Deanna Beckett and Mark Meckler standing by. So, hey, Deanna and Mark, that was not the result we expected out of this committee. I'm assuming that absent committee member kind of doomed us in the vote this morning. Is that your understanding?
Yeah, I mean, so we expected Representative Soy to be a yes vote. We were quite certain of that. She's been out all week, actually. And so that was a definite problem for us. And also, we were surprised by the chairman's vote, to be quite honest with you. We expected him to be a yes vote. We were pretty confident of coming out of this committee. The main thing that I want to say about this, it's we don't like it when stuff like this happens. We're not done in South Dakota. There are procedural methods that we can use, that we are likely to use to probably what's called smoke this out. And we've done it before. We know how to do it. We believe we have the votes to do it. So I think that's probably what's going to happen. I don't want to get ahead of the train here, but that's likely what we're going to do next. We've already conferred briefly with our lobbyists and the folks on the ground here. Even our rep who presented, who was the main presenter, was very surprised by that. I mean, everybody's kind of in a state of shock right now. This is part of the legislative process. The one thing I want to say is that we are not summer soldiers and sunshine patriots. And we're here in the fight, no matter what. The fight's not over in South Dakota. I just want to guarantee you guys that it's not over. We live to fight another day.
Yeah, and like Representative Heineman mentioned, that we do have a bill, a House bill, that will be dropped after this pretty soon for the delegate selection. We used to call it delegate selection. Now it's 34 ready, and that's ready to go. So yeah, we're not done. Shirley knows. Shirley, our state director, has been here. It's her 5th week staying in the capital city, and she knows that the work is not done. So she's planning to stay through the 34 ready bill as well.
Yeah, and I always want to be honest. It's a gut punch when you see a vote go that way, and you're pretty confident that you're going to get the vote on committee, and less confident on the floor. There's just a lot more variables, but you have your whip count on the committee. And Rita, you know this because you're the one who's in charge there at the office of getting us in the whip counts and knowing where we're at. We were pretty good. We knew where we're at, but sometimes people don't show up for the votes, and sometimes people do unexpected things. There was another thing that happened that people might not understand procedurally. So when there's a do not pass vote, this next vote you heard was to move it to the 41st day. That means it's dead. It's essentially off the legislative calendar. And I was surprised because several of the people who voted in favor actually voted then to move it to the 41st day. So we're just going to have to go out. Me and Rick are both here. Now we do what we are here to do, which is we go lobby, we talk to people, we figure out what happened, we regroup, and we make a new plan.
And one of the things that we were listening to, the 2 bills before us, is right at the beginning, they resurrected a bill. They pulled a bill from the 41st day, and they're going to hear it, I believe, Friday. So it can be done.
It is not over. Yeah, we don't want anyone to give up. We have weathered storms like this before. Mark, you mentioned the smokeout procedure. That's what it's called in South Dakota. In other states, it's referred to as a discharge petition or discharge motion. That's basically taking a floor vote to just pull the bill from committee to the floor. So yeah, for those of you watching, it's not over yet. We were shocked by this vote. This is not what we expected in this committee, but we've been shocked by votes before, and we will stay in the battle. Mark, what are you and Deanna headed off to do now?
Hey, we're going to go back and confer with everybody and get to work.
All right. That's what I like to hear. Thanks, guys. So again, we are still in this fight in South Dakota. It's not over till it's over. So you will hear more from us there. And I'll just touch on the opponent testimony briefly before we sign off. Michael Boyle, opponent, he is a pastor, and bless his heart, he claimed that up until last year, we've had no guidance on how a convention works. Well, that's not true. Lots of precedents for interstate conventions, even though we've never had an Article 5 convention yet. Then this was the really astounding thing. He brought up the case of Thompson versus Masterson, which is a case that our very own Michael Ferris was the lead counsel on. And then this pastor, who clearly does not understand what the holding of that case means, went on to talk about it ad nauseum. So that was a little frustrating, but I think, frankly, it may have lulled a lot of people on the committee. He is completely confused about what it means for a case to be justiciable. Just a lot of confusion going on there. And then Scott Granville, opponent, claimed that Congress writes the rules for a convention. He had absolutely zero authority or logic even to back up that claim. Eldon Stahl is, a JBS gentleman who shows up regularly to give opponent testimony. He made almost 0 sense to me, talked about other pending Article 5 applications. Senator Rick Santorum came back for rebuttal and did an incredible job, really set the record straight on that Thompson versus Masterson case. which just really stands for the proposition that the U.S. Constitution is supreme over state constitutions, and the U.S. Constitution gives the power to the state legislatures to apply for an Article 5 convention, not to the people in general of the state. I want to close with this. Senator Santorum urged the committee to step out of the shadows and assert their authority. And he said, when Americans need to step up, we do. So again, this battle isn't over. We weren't successful in this South Dakota House State Affairs Committee today, but we're going to keep fighting and do whatever it takes to pull this resolution, get it through committee and to the floor so that South Dakota can join the ranks of 20 other states that have already applied for an Article 5 convention to propose constitutional amendments that will permanently rein in our runaway federal government. This is Rita Peters. Thanks for watching.